Oh, welcome back to another Tuesday Tips at 2 with the Goldbergs, filmed here from our secret underground studio bunker lair. Yes, today we are filming immediately on the heels of the last video that we just shot. So I really have no idea what's going on in the world when you'll be watching this. Will you even be watching this? Will there be an internet? Will there be the Armageddon? Will the Messiah show up? Will there just be a return to normality and rendering this entire video completely and totally useless? I have no clue. Either way, the practical legal advice that's going to be sent on out in this Tuesday Tips at 2 will be applicable during these unprecedented economic times and also during your normal run-of-the-mill sort of era. I'm going to be broadcasting this primarily for the benefit of most of our pre-existing clients, i.e. small business owners and others that work for small and medium-sized businesses. We're going to be speaking about how to best protect your business against what will likely be an onslaught of owed AR, that's accounts receivables, meaning money that's owed to the business, and how the business can best protect itself. Businesses are going to be hit the hardest during this era. There's going to be mass layoffs. There's going to be a lot of bills that are unpaid. There are going to be a lot of customers that don't sign up to start up some new thing or to buy your product, all while you are often stopped from being able to conduct business because of stay-at-home and shelter orders. Now, of course, this might not apply for toilet paper manufacturers, Purell plants, and others that are generally on the front line, even without any humor about it. But for the rest of us, you should take note. A lot of your clients are going to just avoid paying because they don't have money or because they see an opportunity to avoid paying. And so the best possible defenses to that is being very proactive and taking the following steps. If the AR, that is accounts receivable, money that is owed but unpaid by a customer that you believe can pay, and has the resources to do it, then you should have no mercy on them. It is not the time for someone to be taking advantage of others and the good mercy of others simply because they have an excuse or because they know that many of the courts are shut down. So as such, show them no mercy, start up on it, demand payment, send out invoice reminders, demand letters, even from me or from yourself, and even contemplate filing a lawsuit. The courts might not be open for jury trials, but the county district clerks all across the country, and specifically in Texas, are definitively still accepting new filings of lawsuits. So in case you need to, do contemplate it. If your customer or client cannot pay, or you just wish to give them a lot of tolerance and leeway so that they don't have to stress out over it, here are some steps that you really should internalize and take into effect. 1. Respect and do not ignore the contract or the oral agreement. Your contract, whether it was drafted by you or others, have essential terms that you should remind yourself of, whether on payment terms, timing, what constitutes a default event. And even if it's an oral agreement, there is no written contract, I'm certain that there are some oral terms that everyone's abided by, whether by industry custom or laid out in your own relationship with the client or the customer. So let's say that there's a payment term, net on 30 or so, and you expect payment within that time frame, but you wish to give them leeway or otherwise. Whatever it is, you should remind yourself of what the contractual terms are, and then remind the individual that you're dealing with or the business that you're dealing with that owes you money of what those terms are. Do it in an email, do it in a letter, do not do it in a text message or over the phone alone that cannot later be used for your protection. And I'll get to that in a point. While writing this out, don't just say the terms are XYZ, and that's that. If you do indeed wish to show them some mercy, leeway, wish to work out some new arrangement, make the offer of whatever the change in the terms of the agreement are within writing and state specifically that it's for a temporary period of time. Whatever it is, a change in the payment deadline, offering a payment plan, perhaps waiving late fees or the interest, a refund, a return of inventory, some sort of a quid pro quo, security via collateral that is being offered. Whatever it is, make the offer, make it clear that it's a deviation from the standard contract, and then ask for confirmation, whether a response email or perhaps an addendum to the agreement if that's what the agreement calls for. Sometimes that's a term within the agreement itself. Next up, and I know that we're running over our standard 5-minute increments, but these are trying times. Number 2, avoid waiving any of your contractual rights. Waiver is a legal defense that debtors and defendants can make against breach of contract claim in a lawsuit to say, hey, I know that the contract states XYZ, but the plaintiff, i.e. the party suing me, long ago waived those rights and now cannot enforce them upon me. This would be a good defense for them if you don't do anything in writing, you do change the terms, and then later they wish to abide by the new terms that you offer them during the time of crisis. And so by putting everything in writing and forcing them to confirm and making it very clear that your change of terms is on a temporary basis, you very much help yourself avoid a waiver defense that would later on be argued. Third, calendar deadlines. This is critical. It might be trying times, everyone might be going gaga and crazy, but deadlines still matter. These are deadlines whether they're within your contract, look in the contract, figure it out, put it into your actual calendaring system, or it might be statutorily set in. Statutes of limitation, i.e. the deadline to file a lawsuit, that's 4 years from whenever the contract was breached. And how about this, for all contractors, subcontractors, mechanics men, plumbers, architects, painters, and even suppliers of building material. It is critical that you know your timelines to file mechanicsman liens, or, if unavailable, filing a bond or sending a bond notice to the bonding company on construction projects. Perhaps you don't wish to press upon those that owe you money to press it to actually pay you immediately, but by filing a lien, you preserve your right to collect later. It is too much and too detailed to get into the hard explanation right now of what your deadline might be. Best that you look up online for a reputable source or contact this law office. And I do know that there are some web-based services to help you file your liens. Fourth, maintain communications with the debtors and those that owe you money. 5, stay organized, whatever you do, especially if you're working from home. Make sure that you're keeping the eye on the prize in terms of who owes you money, what's their deadline to pay, what changes in terms you've made for them. Otherwise, I cannot advise you on how else to save your business. I can't come up with other ideas and make pitches to you. That's on you. This is simply helping you gear up for what will be a very difficult time to collect payment from those that already owe you money. Stay tuned next week for another Tuesday Tips at 2 with the Goldbergs.